Hello everyone, welcome to Side Case Reader. Today we are reading the judgment Association of Old Settlers of Sikkim versus Union of India. This judgment was delivered on 13th January 2023, that is last Friday. This judgment was delivered by a bench comprising of Justice M. R. Shah and Justice B. V. Nagaratna. Both of them have written separate judgments, but the main judgment authored by Justice M. R. Shah has also been signed by Justice B.V. Nagaratna. So we can read the main judgment only. So what is the writ petition about? What is this judgment about? For that we have to see this section 1026 AAA highlighted. You can read section 1026 AAA. To give you a brief background, section 10 defines exempted income. Like income in income tax there are various type of incomes which are taxable, and section 10 defines the exempted income. 26 AAA reads as follows. It gives some kind of exemption to Sikkimese people. Like in case of an individual being a Sikkimese, any income which accrues to him or arises to him from any source in the state of Sikkim or by way of dividend or interest on securities, that will be exempted. But now we come to the crucial point. Provided that nothing contained in this clause apply to a Sikkimese woman who on or after the first day of April 2008 marries an individual who is not a Sikkimese. And also see the explanation which defines the term Sikkimese. It mentions about Sikkim Subjects Regulation 1961 and a date 26th day of April 1975. The challenge therefore made in the writ petition was twofold. I will show you that. That is the issue raised in the writ petition. Now see, in para 12, definition of Sikkimese in section 1026 AAA, to the extent it excludes Indians who have settled in Sikkim prior to merger of Sikkim with India on 26/4/1975. This is one part of the challenge. Second part is the proviso, which says that it excludes from the exempted category a Sikkimese woman who marries a non-Sikkimese after 1/4/2008. Regarding the first challenge made, the court noted that there is no difference or distinction between those Sikkim subjects whose name are recorded in the register under 1961 regulations. The judge says merely because at the relevant time when Sikkim subject regulations was enacted, Indians settled in Sikkim did not surrender their Indian citizenship, or that their fathers or forefathers' names are not entered into the register, it cannot be said that they cease to be Sikkimese. That is the observation. And finally, this mentions about Article 14 twin test of classification, and also that a proper classification must have a reasonable and just relation to the things in respect of which it is proposed. Now, it seems to us that the discrimination is based on no classification at all, and it is manifestly baseless, unreasonable, and arbitrary. This is the conclusion regarding the first issue. And regarding the second issue, the judge observed, Justice M. R. Shah observed, that the definition of Sikkimese, the proviso to the section 1026 AA, it excludes woman who has married Sikkimese woman who has married non-Sikkimese after a particular date. Regarding this, judge makes an observation that woman is not a chattel and has an identity of her own, and mere factum of being married ought not to take away that identity. And he adds, gender equality is recognized by the world community in general in this human rights regime. And judge went on to observe that there is no justification shown to fix a cutoff date of 1/4/2008, and even there is no rational nexus to object sought to be achieved by excluding a Sikkimese woman who marries a non-Sikkimese after 1/4/2008. Therefore, the judge holds that the proviso to section 1026 AAA, as insofar as it excludes the Sikkimese woman who marries a non-Sikkimese after 1/4/2008, has to be struck down. So finally, the conclusion made is mentioned in section part paragraph 17, where it says the exclusion of old Indian settlers and also the exclusion of women who married non-Sikkimese is unconstitutional, and that part of section 1026A, insofar as it does these two things, has been struck down. And this judgment has been signed by both judges. Justice M.R. Shah's judgment has been concurred in a way by Justice Nagaratna, although she makes certain other directions in her judgment. She says that both these provisions are discriminatory. So this is all about the judgment rendered by the Supreme Court in uh, this case, Association of All Settlers of Sikkim versus Union of India. Thank you for watching this video. We hope you enjoyed hearing us read this judgment. If you want us to continue further like this, please comment and make your suggestions also. Thank you.